Hello everyone, my name is Amit Jyoti. I am working as an assistant professor with the OP Jindal Global University. In this module, we shall be continuing with our discussion from the previous module regarding the important cases decided by the Inter-American Court of Human Rights. Let us first take the case of Arativa Murillo, that is the in vitro fertilization case versus Costa Rica, decided on November 28, 2012. In vitro fertilization, which is a technique used to help infertile individuals and couples achieve pregnancy by fertilizing the eggs with spermatozoids in laboratory and then reimplanting them in the woman's uterus, was decided and declared to be unconstitutional by the Constitutional Chamber in Costa Rica in the year 2000. Accordingly, infertile individuals who wished to make use of the advances in technology by IVF approached the Commission alleging violation of various rights of the American Convention on Human Rights. The Commission, having made recommendations to the state which were not complied within the allocated 3 months, the Commission referred the matter to the court. The Inter-American Court on Human Rights held that the state of Costa Rica is responsible for the violations of Articles 5 Clause 1, 7, 11 Clause 2 and Article 17 Clause 2, and it instructed it to adopt the same as soon as possible and take appropriate measures to annul the prohibition of practice of IVF so that those persons who are interested to utilize this reproduction technique can do so without any impediment to the exercise of the rights that were declared violated in this judgment. The court, in fact, also instructed Costa Rica to include the availability of IVF within the fertility treatment and programs offered by its healthcare services in keeping with the obligation of guarantee in relation to the principles of non-discrimination. Primarily, the court noted that the right to private life encompasses a series of factors associated with the dignity of the individual, including the ability to develop his or her own personality and aspirations, to determine his or her own identity and to define his or her own personal relationships. The court further indicated that motherhood is an essential part of the free development of a woman's personality. Based on the foregoing, the court finally ruled that whether or not to become a parent is a part of right to private life and includes, as in this case, the decision of whether or not to become a mother or father in the genetic or biological sense. Next, let us discuss the case of Caesar versus Trinidad and Tobago, decided on March 11, 2005. This case deals with the authorization by the state of Trinidad and Tobago of a form of punishment that is incompatible with the right to humane treatment. The argument of the petitioners being that the state is responsible for violating its obligation under Article 2 of the Convention to give domestic legal effect to the rights guaranteed under Article 5, Clause 1 and Clause 2 of the American Convention on Human Rights. This foregoing controversy stemmed from the then standing legislation of Trinidad and Tobago, which allowed for the imposition of corporal punishment. Under the said legislation, a court could order any male offender above the age of 16 years to be struck or flogged with an object called a cat-o'-nine tails. The said cat-o'-nine tails consist of a pileated rope instrument of 9 knotted thongs of cotton cord, each of which was approximately 30 inches long and less than 1/4 of an inch in diameter. For the administration of flogging, the prisoner's physical condition was not a criteria. Also, the evidence on record does suggest that the petitioner in this case screamed out in pain and eventually fainted and spent about 2 months in the infirmary and also suffers from post-traumatic stress disorders. The court unanimously in this case held the state responsible for breach of its obligations under Article 5, Clause 1 and 2 and ordered the court to provide free medical care to the complainant along with taking such legislative measures to abrogate such intrusive corporal punishment. Specifically, the court noted that corporal punishment is inconsistent with the prohibition of torture and cruel, inhuman or degrading treatment or punishment enshrined in the Universal Declaration of Human Rights, ICCPR, UNCAT amongst others. Next is the case of Juan Humberto versus Honduras decided on June 7, 2003. The Commission referred this case to the court where the alleged victim Juan Humberto, who was a collaborator with the guerrilla forces working in the region, was twice detained by the Honduran armed forces for alleged ties with FMLN of El Salvador. While the period of detention continued, the body of the victim was found by the next of the kin in a deep pool which was in a state of decay. There were signs of torture on the body so that his nose and genitals were severed, eyes taken out and other marks on his body that indicated inhumane treatment by the forces. The Inter-American Court of Human Rights, while declaring that the state of Honduras violated the right to personal liberty under Article 7, right to life under Article 4, right to humane treatment under Article 5 amongst others of the victim, ordered the state to pay a total sum of over US dollars 250,000 to be distributed amongst the victim's family members. The court also, in an unprecedented manner, asked the state of Honduras to publicly acknowledge its responsibility regarding the matter along with publishing the operative part of the judgment in a national daily once. Next is the case of Atala Rifo and daughters versus Chile, decided on February 24, 2012. In this case, the initial petition was lodged by Ms. Karen Atala Rifo. We shall be referring to her as only Ms. Atala in our discussion now on, before the Inter-American Commission on November 24, 2004 for discriminatory treatment and arbitrary interference in the private and family life suffered by Ms. Atala due to her sexual orientation. On March 29, 1993, Ms. Atala married Ricardo Jaime Lopez, and with him she had 3 daughters who shall be referred to as M, V and R. In March 2002, Ms. Atala and Mr. Lopez decided to end their marriage through a de facto separation whereby they established by mutual consent that Ms. Atala would maintain the care and custody of the 3 girls in another city where the weekly visits to the home of their father would take place. In November 2002, Miss Emma de Ram, the partner of Miss Atala, began living in the same house with Miss Atala and her 3 daughters. The father in this case, Mr. Ricardo, filed a custody suit in the juvenile court on the grounds that Miss Atala's new sexual lifestyle would be prejudicial to the development of his daughters. The dispute in this court concerned the way disciplinary proceedings were conducted against Miss Atala in this custody suit because of her acknowledged status of a lesbian. On September 17, 2010, the Commission requested the court to declare the violation of Article 11, that is right to privacy, Article 17, Clause 1 and Clause 4, that is rights of the family, Article 19, that is rights of the child, Article 24, that is right to equal protection, and Article 25, that is right to judicial protection of the Convention when read with Article 1, Clause 1 on account of discrimination based on sexual orientation and loss of care and custody by Miss Atala of her daughters in favor of their father, which was done without having any regard to their rights on the basis of alleged discriminatory prejudices. The court held that according to Article 1, Clause 1 of the Convention, any treatment that may be considered discriminatory regarding the exercise of the rights guaranteed in the Constitution is per se incompatible with it. As per Article 24, the states should not carry any action that de jure or de facto discriminates. A right granted to all persons cannot be denied or restricted under any circumstances based on their sexual orientation. The court finds that the determination of the child's best interest in cases involving the care and custody of the minors cannot be used to justify discrimination against the parents based on their sexual orientation. Thus, the court in this case concluded that the grounds stated by the judicial authorities of Chile in justifying custody of the daughters to the father were inappropriate and discriminatory. And the American Convention in Article 24, when read together with Article 1, Clause 1, prohibits any rule, action or practice tantamount to discrimination that is based on any kind of sexual orientation. Next, let us discuss the case of Gomes versus Brazil decided on November 24, 2010. The Inter-American Commission submitted an application in the court on March 26, 2009 against the Federal Republic of Brazil for disappeared person in the context of the Guerrilla do Argua and the next of kin. 70 persons allegedly were arbitrarily detained, tortured and later disappeared during the operations of the Brazilian army between 1972 and 1975, whose purpose it was to eradicate the Guerrilla do Argua in the context of the military dictatorship in Brazil. It was alleged by the Commission that the state did not carry out a criminal investigation so as to prosecute and punish the persons responsible for enforced disappearance of 70 victims. Also, the legislative and administrative measures adopted by the state have unduly restricted the next of kin's right to access any information. The Commission requested the court to declare that the state is responsible for the violation of the rights established in Article 3, which is right to juridical personality, Article 4, which is right to life, Article 5, right to human treatment, Article 7, right to personal liberty, Article 8, right to fair trial, Article 13, freedom of thought and expression, and Article 25, right to judicial protection of the American Convention on Human Rights in relation to the obligations that are enshrined in Article 1, Clause 1, which is the obligation to respect rights, and Article 2, which is domestic legal effects of the same. The court found that acts which constitute enforced disappearance are of a continuous or of a permanent nature, and that its consequences involve multi-offensive violations to the human rights recognized in the American Convention, while the whereabouts of the victims are not determined, or the bodily remains not found, to which states have the corresponding duty to investigate and eventually punish those who are responsible pursuant to the obligations that are derived from the American Convention. The court recalled that the subjection of the detainees to repressive official bodies, state agents, or private persons who act under said acquiescence or tolerance, that with impunity carry out acts of torture and murder, represent itself an infringement to the obligation to prevent violations to the right to personal integrity and right to life established in Articles 5 and 4 of the American Convention. The court insisted that the right to freedom of thought and expression consists of not only the right and freedom to express one's opinion, but also of the right and freedom to seek, receive, and impart information and ideas of all kinds. Therefore, all persons, including the next of kin of the victims of gross human rights violations, have the right to know the truth, and the state authorities cannot resort to mechanisms such as official secret or confidentiality of the information, or reasons of public interest or national security to refuse to supply the information required by the judicial or administrative authorities in charge of the ongoing investigation or pending procedures. The court positively valued that Brazil has adopted measures to progress in search for the victims of the war. But it is necessary that the state carry out all responsible and all possible efforts to determine in the briefest period possible the whereabouts of the disappeared persons, as it has been already more than 30 years by that time. Let us now discuss the case of the Juvenile Re-Education Institute versus Paraguay, decided on September 2, 2004. This case concerns Panchito Lopez Center, a facility for incarcerating children in conflict with the law. The inmate population in the center was increasing, giving rise to inmate overcrowding and a lack of security and safety measures, which resulted in several incidents of fire. A fire at the center on February 11, 2000 left 9 inmates dead and several of them sustained injuries. The center had another fire on February 5, 2001 that left another 9 inmates injured or suffering burns. The center then experienced yet another fire on July 25, 2001, after which the state shut down the center and it transferred the inmates from this center to another center which was meant for adult prisoners. And there were also small-scale transfers to other regional adult penal institutions in the country. With these transfers, now many children shared physical space with adult inmates since these institutions did not have separate infrastructure for juveniles. Subsequently, 2 children died in one of these centers. The conditions under which the inmates at these centers had to live were not only demoralizing them, but they also had both physical and psychological after effect on the inmates. The next of kin of the deceased and injured inmates have also suffered psychological and emotional effects as a result of the death of the inmates and or the injuries that they sustained. The Commission filed the application pursuant to Article 61 of the American Convention seeking a judgment from the court as to whether the state had violated any of its obligations under Article 1, Clause 1 of the American Convention, Article 4, which is right to life of that instrument by virtue of the deaths that have been of the inmates. The Commission also asked the court to decide whether the state had violated Article 5, which gives right to humane treatment of the American Convention in relation to the obligation of the state under Article 1, Clause 1, by virtue of the injuries and smoke inhalation that minors sustained in 3 fires at the original center before being transferred. The Commission also petitioned the court to find that the respondent state had violated Articles 5, which is right to humane treatment, Article 7, right to personal liberty, Article 19, rights of the child, Article 8, right to a fair trial, and Article 25, which is of judicial protection of the American Convention, all in relation to Article 1 thereof, to the detriment of all juveniles incarcerated at the center and those juvenile inmates subsequently remanded to the country's adult prisons. The court, after looking into the facts and the evidence, held that all persons detained have the right to live in prison conditions that are in keeping with their dignity as human beings. And the state must guarantee their right to life and their right to humane treatment even while they are in the prison. The state has a special role to play as guarantor of the rights of those deprived of their freedom as the prison authorities exercise heavy control or command over the persons in their custody. The right to life, the right to humane treatment, freedom of religion, and right to due process cannot be restricted under any circumstances during internment, and any such restriction is prohibited by international law. The conditions at the center where the inmates were kept constituted violation of Article 5, as they were never of the kind that would have enabled those deprived of their liberty to live with dignity. Instead, the inmates were forced to live permanently in inhuman and degrading conditions, exposed to an atmosphere of violence, danger, abuse, corruption, mistrust, promiscuity, where the rule that prevailed was survival of the fittest with all its consequences. The court found that the state violated Article 4, Clause 1 of the American Convention when read with Article 1, Clause 1, and where the victims were children, Article 9 was violated to the detriment of the deceased. Also, the state violated Articles 4, Clause 1, 5, Clause 1, 2, and 6 of the American Convention when read with Article 1, Clause 1. Also, the state was in violation of Article 19 when the victims were children to the detriment of all the inmates interned in the center in period between August 14, 1996 and July 25, 2001. And Articles 5, Clause 1 and 2 of the Convention when read with Article 1, Clause 1 and 19 were violated to the detriment of the children injured as a result of the fires. The court found violations of Article 25 as the state did not provide the inmates at the center with a simple and prompt recourse when the petition of generic habeas corpus was granted. Nor did it provide an effective remedy to the 239 inmates who were put at the center when the court delivered the ruling that granted the petition of habeas corpus. However, court did not find violation of Article 7 as it did not have sufficient information to know the particulars of how preventive detention was used in the case of each individual inmate. The next and the last case here for our discussion is the case of human rights defender versus Guatemala, decided on August 28, 2014. Between 1962 and 1996, an internal armed conflict took place in Guatemala, which had significant human, material, institution, and moral cost involved. During the 1980s, the emergence of new groups of defenders in several areas was met with an intense repressive action by the state, which led to the murder or disappearance of many of their members. The Guatemalan government and the unit, which is the Revolucionaria Nacional Guatemalteca, hereinafter referred as URNG in its abbreviated form, in an effort to reach a negotiated settlement to the conflict, signed the Global Agreement on Human Rights on March 29, 1994. In this agreement, the parties recognized the importance of national institutions and entities for the protection, promotion of human rights, and made a commitment to adopt special measures of protection in favor of individuals or organizations who are working in the field of human rights. Unfortunately, in subsequent years, many acts of harassment and aggression against human rights defenders continued. Now, the Commission alleged before the court that after the signing of the peace accords, which ought to end the internal armed conflict in Guatemala, human rights defenders in that country continued to face a context of threats and attacks on their lives and personal integrity, which constitute a violation of Articles 4 and 5 of the American Convention. The court held that according to Article 1, Clause 1 of the American Convention, the states have the obligation to respect and guarantee the human rights recognized therein. Regarding the rights to life and personal integrity, these obligations not only imply that the state must respect them, that is negative obligation, but also require that the state must adopt all appropriate measures to guarantee them, which constitutes a positive obligation. However, in this case, neither that the Commission nor the representatives did not provide any other evidence to prove that the state should have known about the specific situation of danger in the context of vulnerability for human rights defenders. Therefore, there are no sufficient elements to declare that the state failed in its obligation to protect the life under the terms of Article 4, Clause 1 of the American Convention when read with Article 1, Clause 1 of this convention. But the state failed in its obligation to guarantee the right to personal integrity to one of the human rights defenders and her family through the adoption of adequate and effective special measures of protection in violation of Article 5, Clause 1, read with Article 1, Clause 1 of the American Convention. With respect to freedom of movement of the human rights defenders and their families, the court held that as the state failed in its obligation to provide the necessary conditions to facilitate their voluntary, dignified and safe return to their usual place of residence or their voluntary resettlement in another part of the country, there exists the violation of Article 22, Clause 1 of the American Convention in relation to Article 1, Clause 1 of this convention. Also, state is responsible for the violation of Article 23, Clause 1 of the American Convention in relation to Article 1, Clause 1 of the Convention, as it did not guarantee the necessary conditions to enable Mrs. B.A. to continue to exercise her political rights from the political positions that she held. The court also found flaws in the manner in which investigations for the offences that were committed. The investigation conducted in the domestic jurisdiction has not been diligent, serious and effective, and considers it proven that the state failed to comply with the provisions of Articles 8 Clause 1 and 25 of the Convention read with Article 1 Clause 1. Consequently, the court finds that the state failed to discharge its obligation to investigate the alleged threats with the required diligence, thoroughness and effectiveness in violation of Articles 8 Clause 1 and Article 25 of the Convention to the detriment of the relatives of the human rights defender. With this, we end our discussion on the judgments given by the International Human Rights Court of the Americas. Thank you for listening to this module.